5 seconds to go. Start. This civil appeal is preferred by the appellants claimants in MA number 66 of 2011, preferred before the High Court of Jharkhand at Ranchi, aggrieved by the judgment and order dated 3rd August 2018. Necessary facts in brief for disposal of this appeal are that on 6 September 2004, while the son of the appellant's claimants, which Ibran Ali, a boy aged about 7 years, studying in class 2nd, was standing by the side of the road in front of his maternal grandparents' house, a motorcycle has dashed him, causing grievous injuries resulting in his death. The said vehicle was driven by one Mr. Sunil Gurum and owned by respondent number 1 and insured with respondent number 2. On account of the said accident, which resulted the death of the child of the claimants, they filed a claim petition under section 163A of the Motor Vehicles Act 1988, claiming compensation before the Motor Accidents Claims Tribunal. It was the case of the claimants that the accident has occurred due to rash and negligent driving of the driver of the offending motorcycle. The deceased boy was aged about 7 years at the time of accident and he was studying in class 2nd. The tribunal, by appreciating oral and documentary evidence on record, has come to the conclusion that the accident has occurred due to rash and negligent driving of the motorcycle's driver, which Sunil Gurum. The tribunal, considering notional income of the deceased at rupees 15,000 per annum by applying multiplier 15, awarded compensation of rupees 2,25,000 with interest at the rate of 6% per annum from the date of judgment. Since the driver of the offending motorcycle, Mr. Sunil Groom, was not possessing valid driving license at the time of accident, the tribunal directed respondent number 2 insurance company to pay the compensation to the claimants and recover the same from its owner. Pleading contributory negligence, the insurance company had preferred MA number 115 of 2011 for enhancement of compensation. The claimants have preferred MA number 66 of 2011 before the High Court of Jharkhand at Ranchi. By the impugned judgment, the High Court has dismissed the appeal preferred by the insurance company and partly allowed the appeal preferred by the claimants by awarding a further sum of rupees 15,000 towards funeral expenses. Thus, it is held that the appellants are entitled to a sum of rupees 2,40,000 towards compensation with interest as awarded by the tribunal from the date of filing claim petition. We have heard Sri S.N. Bhat, learned counsel for the appellants and Sri V.S. Chopra, learned counsel for respondent number 2, insurance company. Stop.